you're at Villanova, not at Georgetown.
Professor, not associate, not doctor.
So you're a professor, but you're not a doctor.
Yeah,
Okay.
most law professors don't have PhDs.
Don't have PhDs, right? Which, when I learned that, I was like, are you kidding me?
Yeah, it's very rare. Some, and then David is one of the very few who have PhD not. That's extreme.
David Levin.
Yeah.
Do you have a PowerPoint presentation? Have you set it up to make sure?
I don't know. I'm just going with God. That it's going to just appear.
I don't have a PowerPoint.
Yeah.
Should I go back talk to somebody? Ed said that he was going to check on it.
Okay. It should be okay.
Is that the lights? Yeah.
Oh, you're right. Thank you, Karen. That was in the notes. I should have read.
I didn't see that in the notes. Kind of with these guys, these old guys who just show up.
Yeah.
It's great. It's life of the mind, you know?
Yeah, the bald gentleman is always here. I don't know if he's on the board.
Uh-huh.
Who are you waving at?
Helen. Man, it gets thinner and thinner as the panels go on.
Oh, I think people are still doing
Oh, I think they're upstairs. That's totally a collectivist defense of jus. So you're defending proportionality itself.
Yeah, the more capacious legal and traditionalist view versus analytic, reductive individualist take on it. Just
Counting bodies. Yeah. I said to someone, yeah, it's just about counting bodies. And they're like, no, it's not. And I was like, well, body count does matter. Right? Clearly matters.
So, yeah, have your phone on. Here's the time. Oh. Okay. So, yeah, let's plan on going to 45, and then I'll text you if I want to go. Okay. So, 2 hours or
20.
10 minutes from now.
And my PowerPoint's good to go?
Yeah, they're right.
Thank you.
So good afternoon, everyone. Welcome to the first afternoon session. My name is Theo Christoph. I teach history and international affairs at George Washington University, and I'm also a Stockdale Fellow for the current academic year. And it is my honor and pleasure to introduce our speakers for this session. We have Dr. Brenner Fissell, a professor, who is a professor of law at Villanova Law School, and currently he's also a Stockdale Fellow here at the Naval Academy. His research focuses on substantive criminal law as well as military law, and his scholarship has appeared in general law reviews, including Vanderbilt Law Review and Minnesota Law Review, as well as peer-reviewed journals such as the Legal Theory. Professor Michael Skerker has been teaching here for 15 years at the Naval Academy in the Leadership, Ethics, and Law Department, focusing on police, military, and intelligence ethics. He's the author of The Moral Status of Combatants, as well as An Ethics of Interrogation. He's also the co-editor for Sovereignty and the New Executive Authority, Military Virtue, as well as Cyber Warfare Ethics. So we will go for an hour. So we will begin with Professor Fissell, followed by Professor Skerker.
Thank you, Dr. Christoph. Thanks to Joe Thomas, Ed Barrett, all the other Stockdale Fellows. It's been such a fun year going through the greatest hits of the law of war. I feel like a graduate student again in a good way. So we're going to talk about today something that is probably the most exciting actual legal development in the law of war. It's a 2-year-old regulation called Civilian Harm Mitigation and Response. So I'm going to talk in a very grounded way about what this regulation does, whether or not it's going to survive. Must it survive? So there's going to be some separation of powers observations. But this is, when does a state decide to do more than the law of war requires? Which of course you can do, right? You can do more than the law requires. And the former Deputy Judge Advocate General of the Air Force, Charles Dunlap, in a conversation with Professor Finkelstein at the University of Illinois last month, described this regulation as a festoon on top of the law of war. For those of you who don't know, the festoon is a garland of flowers. So for General Dunlap, the law of war is a solid thing that is really important. And then you got little decorations on top. And so that's what he said this regulation is a festoon. Do you remember that, Claire? Yeah. So, I'm going to tell you what it says, and you can tell me if you agree. This starts in 2019 with the John McCain National Defense Authorization Act, 2019. I believe Senator McCain had just passed away, and they every year there's a National Defense Authorization Act, and they named it after him. And there's a section in that act called Responsibility for Policy on Civilian Casualty Matters. So this is a statute. For those of you who are not lawyers, this is Congress is creating this. And Congress says the Secretary of Defense must do the following. And this is mostly like record keeping. 1, accurately record kinetic strikes. Then 2, and this is the big one, develop best practices for reducing the likelihood of civilian casualties. That's the big one. 3, submit to the United States government allegations of casualties. 4, review and investigate them. And then 5, acknowledge responsibility if we're responsible, and provide ex gratia payments to the families. So mostly what this is I almost want to think of it as a think tank, as trying to develop better practices. They even had an office called the Center for Excellence on Mitigation Harm. So subsection 2 is actually not the most significant part, the festooning, the best practices, but it's the most controversial because it is taking the law of war, the solid wooden thing, and putting some flowers on top. So this is 2019, the John McCain NDAA. The result is a December 2023 Department of Defense instruction, which, for those of you who don't know, the secretaries of cabinets can issue regulations. The Secretary of Defense, at this time it was Lloyd Austin, promulgated DOD-I 3000.17. This is the Civilian Harm Mitigation and Response Policy. I'm going to go right to the section that is the best practices section, the festoon. And I want to read it to you. And listen very carefully, because there are references to the law of war and going above the law of war. DOD components, I'm quoting, that engage in military operations will comply with the law of war requirements for the protection of civilians in accordance with, and then there's various citations, including by taking feasible precautions, but commanders should take additional protective measures not required by the law of war. Commanders should take additional protective measures not required by the law of war, as they deem appropriate, to the circumstances when planning and conducting military operations. And then there are 4 things. So commanders should consider these 4 things. 1, consider other possible alternatives to an attack against a military objective, even when the attack would be lawful. So I guess this would be like withdrawing from the house with the people on the roof, like we talked about earlier. 2, issue standards for the identification of targets above what the law of war requires. 3, and we're going to talk about this, select for the employment of weapon systems or munitions that may help mitigate civilian harm, e.g., precision-guided munitions. And then ... even when employment of such weapon systems would be lawful. And then there's a catch-all. Take other precautions not required by the law of war. So 2 and 3 are the most substantive. They say, 1, you must issue standards for targeting above what the law of war requires. And 3, you have to choose precision-guided munitions, if feasible, above what the law of war requires. I want to focus on the second one. it's clear that the law of war does not require precision-guided munitions. The Law of War Manual, section 14.9.2, I'm quoting, "It must be emphasized that the selection of appropriate weapons remains primarily a military judgment rather than a legal one. In particular, there is no law of war requirement to use precision-guided weapons." In a 2023 lecture at the JAG School, Professor Blank, who was here yesterday, said, "We know that just because you have precision-guided munitions, you do not have to use them." So that's the law of war. The festoon says, if feasible, you must. So we should talk about that. My overall conclusion is that there are so many holes in this, and it is so vague that it really doesn't affect many substantive changes. So to say that commanders only need to look at the 4 components as they deem appropriate, that's a major caveat right off the bat. So how many times do you think that's going to be invoked? Is it really changing the rules of conduct if there's a discretionary opt-out right up front? So, but let's go back to this precision-guided thing. So we know that that is not a part of the law of war, yet it is going to be, there's pressure at least, I think, based on this reg to be using precision-guided munitions. Query whether or not, is the festoon aimed at anything other than aerial targeting? I'm not sure it is. I'm not sure that when you read these things that you're thinking about, say, tanks or trench warfare like is happening in Ukraine. So the last thing I want to talk about is the separation of powers. So there are some developments related to this program that have occurred in the last 2 months. The Secretary of the Army in the first week has asked the Pentagon to rescind the DODI. The Secretary has the power to do that. The Secretary has not rescinded the DODI. However, the Secretary has fired most of the staff who would implement it. So what we have now is a situation where the substantive policy, the festoon remains, but the people who would be collecting the data, giving the ex gratia payments, they don't exist. Somebody outside said that his friend was fired from that office recently. So we have a policy, but we don't have people to collect the data. But nevertheless, the substantive rules remain. Now, I am going to submit to you that even if the Secretary rescinded DODI, the DODI from 2023, he would still be compelled to issue another one. The statute says the Secretary must develop best practices for reducing the likelihood of civilian casualties. So to rescind the DODI without replacing it, in my view, would be violating this statute. Some of you who might be saying, but the president can do whatever he wants because he's the commander-in-chief with respect to rules of engagement. The president is the commander-in-chief, but there's another clause in the Constitution which many of you probably don't know about. It's called the Make Rules Clause. Congress makes rules for the land and naval forces. Congress defines and punishes offenses against the law of nations. These are explicit textual commitments in Article 1 of the Constitution to Congress. So that is buttressing up against the commander-in-chief authority. So I think if the policy is rescinded, it would need to be replaced as a matter of just congressional power. Thank you.
Good afternoon. I want to start by thanking Ed, Joe, Sarah, and Karin for bringing this together. I'm going to talk about proportionality today. So as you know, proportionality is one of the main principles of jus in bello and one of the main elements of the law of armed conflict, LOAC. What I want to do here is address the following dilemma related to proportionality, or dilemma as I see it. In bello and LOAC construals of proportionality appear to give immoral latitude to incur significant numbers of collateral non-combatant casualties relative to the immediate military aims and to attack enemy troops who are not posing immediate threats, sometimes causing collateral damage in the process. But these tactics, which seem to be ruled out by individual-centered morality, also appear to be necessary, at least sometimes, to win just wars. Observing more restrictive, individual-centered moral principles of justified violence, familiar from civilian life, would seem to prevent militaries from efficiently and successfully fighting these wars. So a dilemma. Militaries, at least in basically just states, have a moral duty to fight and win efficiently just wars, but apparently must do so using immoral means. In this piece, I've written an article, this is obviously a condensed version of it. I'm going to try to articulate a collectivist account of justified military violence that can dissolve this dilemma by supporting the practically efficacious standards of in bello and legal proportionality. So, as most of us know, you can fill a bookcase with all the writings on other defense and self-defense. Let me try to state a very brief account of an individual-centered version of other defense. One can violently intervene to defend an innocent party from an imminent, unjust attack by at least a culpable attacker using proportionate and necessary force. On an internal construal of liability that many individualist philosophers endorse, a culpable attacker is liable to a specific quantum of force that's dictated by the level of harm he threatens to inflict on his victim and the harm which is subjectively necessary for the intervening party to use to effectively halt the attack. Many scholars argue that one may not collaterally kill an innocent bystander in order to save one person while engaging in justified defensive violence against a liable attacker. We just talked about this with the Human Shields case last session. One should not, for example, throw a grenade at a terrorist who is about to shoot an innocent person if the grenade blast will also kill another innocent bystander in the blast radius. Now, some people do grant permission to collaterally kill one bystander to save oneself. They're probably in the minority. Or even 2 or 3 bystanders in order to rescue someone to whom one has a special obligation, like one's child. Absent those qualifiers, though, a non-liable life equals one non-liable life, and one cannot be set aside for another. Now, here's the problem. Conventional just war theory and LOAC depart from this one-to-one standard and the aforementioned imminence requirement for just other defense in several ways. As both the traditional norm of in bello and the law of war is often interpreted, combatants can collaterally kill n plus non-combatants in order to save n allied combatants or kill n enemy combatants. Regarding imminence, it's commonplace in modern militaries for militaries to attack enemy targets from far away, when enemies' weapons are outranged, when enemy troops otherwise pose no imminent harm to the attacker, when they're in training, when they're in transit, when they're asleep, or when they are full-time offering non-kinetic support roles. In these cases, the harms that are prevented to allied non-combatants are wholly speculative, but in the way that American JAGs interpret it, and many traditionalist just war theorists interpret proportionality, you can use that speculative harm that is forestalled, count that against non-combatant casualties that might be incurred with that long-distance strike. Now, to clarify, some scholars, including reductive individualists, and this is for the students who might not know about reductive individualists, some of them dispense with the imminence requirement, seeing it as often implied by necessity. So they might be able to wave away half of my so-called dilemma by saying that it could be necessary to attack long-range prospective threats who are deemed liable. So I'm going to go on a 2.5-minute tangent to address that critique. We can think of some examples where it's intuitively permissible to kill a non-imminent threat, such as a sleeping abusive spouse. There were some famous court cases in the US involving that very thing, and a plethora of legal literature on that very subject. Unpacking these and similar cases suggests that imminence usually stands in for 3 sub-elements that still obtain in some non-imminent threat cases: certainty about the threat, an absence of escape options, and an absence of intervening authorities. These are all present in the paradigmatic case of imminence where someone is, say, pointing a gun at you or swinging his fist at you. The threat is clear, it's too late to escape, and clearly the authorities have failed to protect you. In a non-standard case, or a case of a non-imminent threat, for example, a woman is not imminently threatened by her sleeping abusive spouse, but she knows he has a settled disposition to harm her. She may lack escape options because he controls her finances and has threatened to follow her wherever she goes, and the police may have refused to intervene in the past. So, granted, necessary and proportionate levels of force can be justified against non-imminent, possible, long-term threats. But, here's my claim, only if they have a settled and an implacable disposition to harm you, you have no escape options from their effective area of control, and you're in a state of nature kind of environment where the authorities are not going to rescue you. While they are in a state of nature type environment in war, some combatants may be outside long-distance threats' area of effective control, depending on their surveillance and strike abilities. But here's the thing, they will likely not be able to judge individual enemy combatants' settled disposition to threaten without helping themselves to collective ideas of corporate responsibility, participatory intention, and liability through group membership that individualists need to reject on the pain of inconsistency. So it seems to me that by individualist lights, it remains morally problematic for service personnel to attack long-range targets that do not pose an imminent threat to the agent. A basic tenet of the reductive individualist approach to just war theory is that individualist morality has to apply to all facets of life, including war. Regarding a military extension of the individualist account of justified violence, it would be an extraordinarily inefficient, ineffective, and unreliable way to fight a war if service members had to adhere to individual-centered rules for self and other defense, waiting until lethal force was a narrowly proportionate and minimally harmful means of warding off imminent danger. Mobile units continually reposition to avoid confrontations, thereby denying both sides a justification for violence. Wars would drag on indefinitely because units could not aggressively pursue their enemies, meaning that the unjust cost precipitating the war would not be addressed. Governments would bleed funds, non-combatants would be exposed to constant danger. Regarding prohibitions on killing non-imminent threats, personnel would be prohibited from killing sleeping, repositioning, or distant troops. Ambushes would be ruled out. Support personnel, who constitute the majority of modern militaries, would be off limits. Because they're only partially liable for posing a lethal threat to those with the ability to target them, and they pose no imminent threat. Combatants would only be permitted to fight in the riskiest moments, when the enemy was an imminent threat and posed a proportionate threat to the individual soldier with the ability to fight. Now, even if I'm wrong about imminence, this argument I made about the three sub-elements, it seems to me that reductive individualists will still struggle to justify lethally targeting support personnel who are only tangentially involved in violent actions and therefore only partially liable to force. So, continuing now with the analysis of individual-centered rules, regarding wide proportionality that compares the good done for the agent versus damage to collaterally harmed civilians, service personnel would often be barred from attacking military targets if the ratio of collaterally killed non-combatants was too high compared to allied non-combatants saved. So I found this literature quite interesting. The most permissive individualist take on other defense would permit a 3-to-1 collaterally killed to saved ratio in a scenario where one redirects a pre-existing threat away from your child, say, towards a group of strangers. But our friend Jeff McMahon points out that most combat scenarios involve creating a new threat to one group in order to rescue a second group. So you're not redirecting a missile that's already been fired, you're the one firing the missile. Since killing is worse than failing to rescue, and a 1-to-5 ratio of strangers saved to strangers collaterally killed seems to be widely accepted, as in the canonical trolley case, the more typical combat collateral killing scenario, McMahon argues, requires a 1-to-6 ratio of collaterally killed to saved people. So I want to repeat that. So on McMahon's view, that you could potentially kill up to one person collaterally if you're saving 6 people. So that's a heck of a ratio. Even putting the complications of anticipating the future epistemic problems aside, it seems on its face that very few combat actions in densely populated areas could occur if combatants could only collaterally kill one non-combatant if they are reasonably confident that they would be saving 6 other non-combatants in the course of the attack. Now, these practical limitations are morally important because militaries sometimes have to fight just wars, when efficiently defeating the enemy, preserving Allied lives, materiel, limiting the exposure of non-combatants to risk is morally important. Now, I want to underline the issue of efficiency here, because I think sometimes scholars are apt to wave away military science concerns about efficiently defeating the military. The Russian invasion of Ukraine brought this home, that it is important to quickly kill invading soldiers, particularly if they're set on looting and rape, that it's important to quickly stop them. Some individualists develop arguments taking into account scenarios where individuals collaborate with others to create a collective threat. Now, I'm not going to read this part. I'm going to just let you read the slide here in the interest of time. I think these aggregation projects don't work because what scholars try to do is aggregate partially liable actors. If we think about a patrol aircraft sinking a destroyer that's far away from the Allied coast and not posing an imminent threat, the large numbers of sailors poses a challenge to aggregating the risk. The argument that scholars make is that you are only liable to necessary force, and if you have to kill the entire ship of people to defeat the ship, then no one person is liable. Some individuals appeal to a lesser evil argument, but that does seem to be vulnerable to a double counting objection. So I'm going to just leave that there and move on. I want to now articulate with the rest of my time my collectivist account. And of course, elsewhere I try to do this in much greater length. This is a compact version. Yeah. Actually, we'll go back one. The individualist approach to justified violence appears to rule out common military tactics that are necessary to efficiently fight just wars. If there's currently no realistic way to reform effective tactics, then militaries confront a dilemma of being morally obligated to use immoral tactics to fight just wars. Again, there seems to be a dilemma there. The dilemma dissolves if there is a morality especially applicable to the military that permits efficacious tactics. Wouldn't that be nice? Now, the following part of my paper here articulates a partial collectivist account of military violence that supports such tactics. Elsewhere in my book, I argue that a collectivist account of justified military violence is not separate from ordinary, everyday, individual-centered morality, but rather is the institutionally mediated expression of that ordinary morality that role actors have a duty to adopt in order to deliver the signal goods of their important profession. I can't pursue the broader argument about its foundation here, though it's wonderful. But instead, though I just read Uwe Steinhoff's critique of one of my papers, and apparently I'm very stupid, but who knows? Those are the risks you run. Instead, I'm going to make 2 arguments here trying to motivate the acceptance of some kind of collectivist account of justified military violence. It doesn't have to be mine, but some kind of account of justified military violence. Collectivist military violence. So, reductive individualists argue that there is a single morality pertaining to all facets of life, no moral holidays, no exceptions for the military or for any kind of collective. Now, this foundational claim, I think, can be shown to be false because what's proportional for a group to do in a collective action is more than the sum of what's proportional for its members to do in each of their relevant contributory actions. So if anyone is propounding a collectivist account, you have to overcome the reductivist argument saying, look, there's just one morality. You can't introduce this collectivist version of moralities. So this is my attempt to do that. So groups may have different goods associated with their goals than the goods of their members, because groups can accomplish greater goals through cooperation, efficiency created through hierarchy, and the like than individuals can accomplish on their own. The good in a group's proportionality calculation that the leaders might be responsible for thinking about then can be more than the aggregate of any goods their members pursue in individual proportionality calculations. Further, the good identified in the ad bellum proportionality calculation will not reduce down to service members' tactical goods. When political leaders and military advisors consider going to war, they might consider strategies with different mixes of benefits and risks. So for example, if a state seeks to aid an invaded ally and the intervening military attacks from the north, for example, the enemy's unimpeded southern forces will impose certain damages to the allied force. The leadership's decision to attack from the north create the conditions for service personnel in the north to choose actions with different ratios of tactical goods to collateral harms. But the service personnel cannot affect the disvalues created by the enemy's unimpeded actions in the south. While these anticipated disvalues went into the leadership's ad bellum proportionality calculation, they are not included in any aggregate of all the goods and disvalues created by service members' individual actions in the north, because the northern force is not in the south affecting those values. So, whatever the merits of a particular individual-centered version of other defense is, I think we are not obliged to apply the individual's account to collective action in war. We thus have conceptual reasons, in addition to the practical reasons I already talked about, to turn aside individualists' objection to traditional in bello and LOAC proportionality's toleration of N plus non-combatant casualties and the targeting of non-imminent threats. So here's my collectivist account, again very briefly. In war, it is appropriate to collectivize imminence, to consider the whole enemy military as a certain and unavoidable collective threat to its adversary in a state of nature-like environment. Because, by design, its elements are interdependent, centrally organized, monitored, and controlled, and by practice, some part of it is always attacking, pursuing, or planning to attack the enemy military, the agent military, sorry. We can then see that it can be necessary in a collective sense of necessity for the agent to take action against the enemy military whenever and wherever it is tactically sound. By analogy, a defender can kick an attacker in the stomach even though an attacker is only using his fists to pummel the defender. Further, unlike a violent encounter in the civilian world, which is typically a one-off event, a war is a period of time in which two or more institutions engage in repeated violent acts intended by both sides' planners to integrate into a coherent, goal-oriented strategy. So it seems sensible to me to conceive of war as a single temporal event in which the value of a given attack must be judged against the strategy of the whole war. The proportionality of a ship's sinking, therefore, can include the lives saved downstream on account of the ship's absence. So let me talk about how this collectivist account can justify attacking non-imminent threats. So let's say we can think of soldiers who are training in a far-off base that's far from the agent military as part of a collective imminent threat, even though these soldiers are, let's say, a week away from deployment, a week away from being finished in their training. They're part of a military machine, a military organism that is always posing a threat in some way to the agent military. It might cause the minimal level of harm to the enemy military if the agent attacks that training base as opposed to some other element, or attacks some rear echelon command center or communications node as opposed to even some frontline troops. It might be proportional collectivist sense to attack that far-off training element because we can weigh the good done to the agent military against the harm done to that training element. So maybe we kill a company of training soldiers, but we end up saving 3 companies on the agent side long term. Now let me turn to trying to justify the harder thing, the sadder thing. I mean, look, we're talking about dead babies here, and I think about that. When I spent the last 2 years working these articles, and I look every day at this picture of my 5-year-old son on my desk, and so I try to remember what I'm talking about here. I'm talking about dead children. I'm talking about how many children we can justify killing. Since service personnel have the training, ability, and orders to preserve the lives of their colleagues directly, and the lives of allied combatants and non-combatants indirectly by attacking enemy forces, each service member can potentially preserve the lives of multiple people over the service member's tour of duty. This is how, broadly speaking, a service member can be worth multiple non-combatant lives in a proportionality calculation. It is not that one of our soldiers is worth more of those civilians because of the agent's partiality, nationality, the liability of either party, or any kind of deontological difference between doing and allowing, but simply because of the service member's ability to preserve multiple lives. Saving N service members might preserve N plus combatants and non-combatants long term. They're preserving a fellow combatant lives and taking of enemy combatant lives can create a modest exponential effect that saves more non-combatants on all sides of the conflict long term. So in conclusion, what I've tried to do here is try to understand how, if at all, the relatively liberal permissions of traditional in bello and LOAC proportionality, the relatively liberal permissions they give to agents to cause collateral damage and to attack non-imminent soldiers, non-imminent threats, can be justified at all. The impetus to try to justify what on its face seems immoral is because it seems like we need these tactics to win just wars efficiently. I've deployed this collectivist account to try to do that. So I look forward to your questions. Thank you.
In the sun, too. I think he's right.
Thank you so much, Professors Fissell and Skerker. We have now time for questions, reflections. Please come forward and introduce yourselves. Yes, with Professor Neff.
Yes, thank